is still pending. Post this case on 9th of May, rather 8th of May, awaiting the result of it. Not that pending, but when we went, 9th May, last working day.
Orders notified at a meet first appeal 37 of 2024.
Two interlocutory applications. One is under Rule 96. Appellant number 2 to 5 has pointed out that they are not party to the awardee. Actually, the original.
After the decree?
After decree, he had died due to cancer. Not that time. Therefore,
legal
has already, appellant number 2 to 5 is already included as parties in the
date of death?
Date of death is
23/12.
That defect may be ignored. And another is IA for concerning the delay of 201 days.
IA number 859 of 2025. The counsel for the appellant has submitted that the appellant number 2 that the awardee, namely Vijay Pandey,
Yes.
son of Abhay Kumar Pandey, who was an awardee in the land acquisition case, has expired after the judgment and decree. And his legal heirs are appellant number 2 to 5, and accordingly the defect in connection with party possession, considering the aforesaid submissions, the defect in connection with party position of appellant number 2 to 5 is ignored. That's it.
Yes.
There
is delay of 201 days.
Who is for the respondent?
The respondent state is the respondent. And the delay ground is that the awardee number 2, he was detected cancer and entire family members were engaged. I've annexed all those documents from July to
IA number 858 of 2025. This petition has been filed seeking condonation of delay of
201 days.
201 days. The learned counsel for the appellant has submitted that the awardee number 2 was suffering from cancer, and therefore there has been delay in filing the appeal. Nobody is appearing on behalf of the respondents to oppose the bread, and no counter affidavit as such has been filed to the interlocutory application. The interlocutory application is also supported by medical documents.
Yes, medical documents. Tata Memorial.
Considering the aforesaid submissions, IA number 858 of 2025 seeking condonation of delay in filing the present appeal is hereby allowed.
The appeal is on limited point with regard to the building, commercial building.
The learned counsel has submitted at this stage. The learned counsel has submitted that the appeal is on the limited point with respect to the valuation of the building. Admit call for LCR. Pose this case under the heading for final disposal on 20 March, where the records be called for from the concerned court. Since all the respondents railways में है ना,
रेलवे को पार्टीज कॉपी सर्व किया हुआ है अनिल
now appear कर रहा है.
yes that was also a defect. Copies should be served to the railway council.
Appear कर रहा है नाम चेक करो.
अनिल कुमार
let a copy of this admit call for LCR. Since the respondents are represented through their retained counsel, no notice need be issued to them. Let a soft copy of this order be forwarded to the learned counsel for the respondents, so that they may get ready for final disposal of the matter.
Item 9, first appeal 167 of 2024.
Yes.
Two IAs are there, but that has not been served upon us.
What are the ideas? ट्रांसपोजिंग के लिए है इसका आपको कॉपी नहीं सर्व किया आप कौन
I'm the state notice.
स्टेट
Yes.
nobody appears on behalf of the appellant. The learned counsel for the opposite for the respondent state has submitted that he has not been served with a copy of IA number 12 of 2025 and also IA number 15 of 2025. The counsel for the appellant is directed to serve the copy of the interlocutory applications to the learned counsel for the state. State में किसका नाम लिखा है? Within a period of 1 week, let a soft copy of this order be communicated to the counsel for the appellant for compliance. Post this case on the counter affidavit, if any, be filed by the respondents by 5th of March. Post this case on 6th of March in the supplementary of this counter affidavit.
For admission item 15, first appeal 21 of 2025.
Nobody appears on behalf of the parties. Are you there for the appellant?
I have been told to seek Passover in this matter.
पासओवर किस लिए एडमिट कर देते हैं? बुलाइए, तुरंत बुलाइए इसको एडमिट करने के लिए पासओवर का कुछ
नहीं,
ऐसे नहीं। कौन है काउंसिल?
समीर कुमार।
हाँ तो बुलाइए उनको। Call him in 10-15 minutes.
For hearing under order 41 rule 11, item 16, second appeal 567 of 2016.
In
Yes.
this matter I am not ready. In the next case I am ready.
ये क्या मतलब? Not ready, why not ready? आपको फाइन करके ना टाइम हुआ था पिछली बार?
Only pray for.
And again you are not ready. आप बहस करिए। ऐसे time नहीं
Next serial number 17 I am ready.
नहीं, इसको बहस
इसको
करिए।
कल पर रख लीजिए।
नहीं रख सकते ना। You are doing this.
It is my first difficulty.
फाइन करके आपको टाइम मिलता है, फिर भी आपको टाइम चाहिए।
कल के लिए नेक्स्ट केस आई एम रेडी। serial number 17. कल पर इसका
नहीं ऐसे नहीं करता। क्या मैटर है भाई, थोड़ा तो बताइए। लैंडलॉर्ड टेनेंट रिलेशनशिप में आपको इतना लड़ाई करना है?
नहीं, एविक्शन टाइटल सूट हम फाइल किए थे। एविक्शन टाइटल सूट में डिसमिस कर दिया। appeal lords. Appeal was
This is
also.
for what purpose? You are the landlord.
I am the landlord lordship.
Why was
On
it
the ground of
dismissed?
default lordship.
On the ground of?
On the ground of default, we filed the.
That's right. Why was it dismissed?
It was dismissed as the defendant are claiming lordship. They obtained this suit land lordship by way of hukum, sada hukumnama lordship. But we have purchased the said land from the real owner lordship.
Real owner means? From the descendants of Sada Hukum, from the recorded tenant?
No lordship. Defendants are claiming that they are claiming on the basis of sada hukum.
That's right.
We are claiming lordship. We have.
Is there any document regarding payment of rent?
Yes, lordship. Payment of rent is also, they have also admitted lordship. We have sent legal. इसमें हुआ क्या कि भुवनेश्वरी प्रसाद
कल सुन।
हाँ कल पे सुन
SA number 567 of 2016. The counsel for the appellant submits that he is not ready in this case today. He prays that the matter be posted tomorrow. Post this case tomorrow to be taken up as the first case attempted. नहीं आइएगा तो डिसमिस कर देंगे हम लोग 10:30 बजे. सिंपल. चलिए नेक्स्ट. थोड़ा शॉर्ट नोट बनाएंगे.
Item 17, second appeal 235 of 2018.
Currently, see last order lordship, order number 6 lordship, 20th January 2025 lordship.
पढ़िए.
My lord was pleased to that the
पढ़िए.
my lord report.
You read the order.
Yes. Learned counsel for the appellant has submitted that the record of the case be called from the learned court concerned as the date and written statement is required to be deduced by this court. He submitted it was never with the case of the either party that one or the other party was tenant under one or of the other party. He
Record
also
है.
yes record.
अब जरा जजमेंट पढ़िए. पहले जजमेंट पढ़िए फिर
Yes,
रिकॉर्ड.
lordship.
You are the plaintiff or the defendant?
I was the plaintiff lordship. We preferred
Suit dismissed.
suit dismissed lordship. We also preferred appeal lordship. Appeal also dismissed.
Now let us see
Yes.
what was the
The-
respective case as recorded in the order.
Yes, lordship. Can you come to the learned trial court lordship?
Yes, trial.
Issue framed by the learned trial court.
Yes. No, not the issue. I want to see the case of
Yes,
respective
yes.
parties.
Case of the.
Yes, case of the parties.
Yes, lordship.
Just read it.
One.
Para 1 se पढ़िए.
Para one. The present suit has been brought on behalf of the plaintiff for the of partition to the extent of half share. We are not paying for partition. Wrongly it was filed for partition lordship. Alternative waiver was also there lordship. Half share in the suit property described more fully and specifically in the schedule to the print and in alternative for declaration of the title over the portion of the suit property purchased through registered sale deed dated 25/174. We purchased the land through registered sale deed lordship 25/174. The case of the plaintiff as made out in the print in nutshell is that the suit property as described in schedule to the print originally belonged to the one Daso Sahu, alias Daso Halwai, who was survived by his son Doman Sahu and two daughters, Radha Devi and Gaura Devi. It is also the admitted case of the plaintiff that Doman Sahu and Radha Devi sold southern half portion of the entire suit property in favor of the plaintiff by virtue of registered deed of sale dated 25/1/1974, while Gaura Devi by registered sale deed dated 9/2/74 sold and transferred 3 Ana share in the entire suit property to the Chiranjeev Lal Agarwal, son of Rameshwar Lal Agarwal. Different number 4. It is also the admitted case that all the 3 legal heirs of Daso Halwai further admitted that the remaining 5 Ana shares in the entire suit property by virtue of sale deed dated 19/4/74 in favor of Pawan Kumar Agarwal and Jay Kumar Agarwal. Different number 2 and 3 herein the case of the plaintiff therefore it is that the legal heir of the Daso Halwai had jointly possessed the entire suit and the said joint property was transferred on sale by thereon by the plaintiff and defendants here without any partition by bids and bonds. The case of the plaintiff further is that prior to the purchase by him, he was in possession of the portion of the suit property on the southwest corner measuring 17 feet by 30 feet, being the tenant of his vendor, while defendant number 1 was a tenant over the remaining portion of the entire suit portion of as it northwest portion including the adjoining land towards the northeast portion of the suit property. However, according to the plaintiff, the remaining portion of the plot on the southeastern portion and adjacent is to the shop of the plaintiff remained vacant and under the possession through a door opening in the passage of the eastern side. Furthermore, the plaintiff had mutated his name in the revenue record of the local municipality and thereafter had erected a brick boundary running east to west as per the convenience without any partition by bids and bonds. The plaintiff therefore demanded a partition by bids and bonds due to this difficulty in this portion under this occupation, the same being in deliberated condition but the defendant consistently deferred the matter till February 1995. The defendants, according to the plaintiff, upon measurement of entire suit property, changed their mind and claimed the entire portion other than the shop of the plaintiff to be their own due to the while proceeding under section 144 CRPC was initiated with respect to the southeastern portion of the suit property measuring 14 feet by 17 feet. According to the plaintiff, the defendant in their show cause filed in their proceeding under section 144 CRPC laid claim over the suit property and further alleged that the plaintiff was in illegal possession of an area measuring 4 feet by 30 feet belonged to the defendant, which was allowed to possess on mutual settlement and in lieu of land measuring 14 feet by 17 feet. It is further the case of the plaintiff that during the pendency of the proceeding, the defendant illegally obtained an order from SDO for measurement of land by circuit officer and illegally and forcibly demolished portion of the wall erected by the plaintiff. Though the plaintiff filed a petition under section 188 CPC IPC for punitive action against the defendant for violation of probatory order, but the circuit officer, in connivance with the defendant, submitted incorrect report before the subdivisional officer who filed order dated 17/4/1995 illegally vacated the rules under section 144 CRPC against defendant number 1. Though the plaintiff preferred criminal negligence 74/95 before the session judge Hazaribagh, but the same was also disposed of by order dated 3/36/1995. It is further in the case of the plaintiff that proceeding under section 144 CRPC in
It was your specific case that you were in possession of a portion of the property in the capacity of the tenant.
No.
Yes.
Earlier, both the plaintiff and defendant were in the position in the capacity of tenant of the.
But there is a specific plea that you were in the possession of the property in the capacity of a tenant.
Both yes, lordship. Both plaintiff and defendant lordship, but plaintiff purchased the land lordship on night, that is exhibit 3 lordship. Exhibit 3 lordship purchased from the.
And what was the issues framed?
Yes, issue frame. That is.
You had submitted on the last occasion that there was it was never the case of either party that one or the other party was a tenant in the premises.
Yes.
So आपके तो केसी में लिखा हुआ है that you claimed that you were a tenant on the property.
नहीं हम tenant वो वही confusion हो गया समझने में दासो साहू original owner थे.
आपके समझने में जो गलती
नहीं
हुआ तो इस तरह
हमारे
से जो इस तरह से
court,
submissions-
the first appellate court is considered the fact or
नहीं first appellate court नहीं पहले trial court की बात.
trial court.
Was it your case that you were a tenant in one of the portion of the property?
Yes, earlier I was a tenant lordship, but on 9/2/74.
That is okay. Subsequently, you ceased to be a tenant. Therefore, your submission on 21/20/25 is not correct.
Look, we purchased the land through.
That is a separate thing. You made a statement that it was never the case of the either party that they were tenant in the property. This is not correct.
No, both are not tenant lordship. Both plaintiff and defendant were tenant of दासो साहू lordship.
आपका जो statement इसमें लिखे हैं submission
हाँ,
गलत लिखे हैं.
नहीं वही है कि दोनों
He
एक
submits that it was never the case of either party that one or the other party was tenant under one or the other.
वही फर्स्ट अपीलेट कोर्ट बोले कि हमको एविक्शन सूट फाइल बीबीसी एक्ट में एविक्शन सूट फाइल करना चाहिए क्योंकि डिफेंडेंट हमारे टेनेंट थे. हम लोग दोनों टेनेंट थे दासो साहू के, दासो एलियस दासो हलवाई के. दासो साहू के एक बेटा डोमन साहू और राधा देवी. ये एग्जिबिट 3 है जो 25/174 को हाफ पोर्शन जमीन हमारे फेवर में सेडेड कर दी. और जो उनकी जो सेकंड बेटी थी गौरा देवी वो रेस्ट हाफ पोर्शन की एग्जिबिट C और C/1 है वो डिफेंडेंट के नाम के फेवर में एक्सिक्यूट कर दी. तो दोनों को हम लोग टेनेंट पहले थे लेकिन बाद में दोनों को परचेस कर दिया. हाँ, इस कंफ्यूजन बस ये है कि दोनों एक दूसरे में आपस में रिलेटिव भी थे. तो हाफ पोर्शन तो हम अपना रजिस्ट्री कर लिए, म्यूटेशन भी हो गया. लेकिन मेरे हाफ पोर्शन में जो पहले टेनेंट थे उसका हाफ पोर्शन में वो वहाँ पर उनका दुकान चलता था. दुकान में वो
नहीं आपका जो पोर्शन था आपने खरीद लिया.
हाँ,
उनका जो पोर्शन था उन्होंने खरीद लिया.
हाँ, तो मेरे पोर्शन हाफ पोर्शन वो इलीगली इंक्रोच करके पोजीशन करके वो बोले पैरा 23 में WS में फाइल किया कि हम एडवर्स पोजीशन के ग्राउंड पे क्लेम कर रहे हैं मेरे हाफ पोर्शन पे.
तो उनका क्या एडवर्स पोजीशन डिक्लेयर कर दिया है?
उसी के ग्राउंड पे जो फर्स्ट. हाँ,
उनका एडवर्स पोजीशन डिक्लेयर कर दिया है.
नहीं एडवर्स पोजीशन इसमें पैरा इसमें जो ट्रायल कोर्ट का जजमेंट इसमें फाइंडिंग आया है जैसे 74 में हम परचेस किए तो हमको सूट लाना चाहिए था विदिन 12 इयर्स. उसी बेसिस पर मेरा डिसमिस किया. जबकि जो एडवर्स पोजीशन के ग्राउंड जो कहीं पर डेट कहीं मेंशन नहीं की है. एडवर्स पोजीशन में बहुत सारे जजमेंट हो जो हम देखना है कि जब जिस दिन से डेट वो डिस्क्लोज करेंगे किस डेट से हम एडवर्स पोजीशन पे है तब हम सूट लाएंगे. तो ट्रायल कोर्ट मेरा कैंडिडेट देखा जब पेज पैरा 32 वाला ट्रायल कोर्ट जजमेंट लॉर्ड से.
तो अभी पार्टीशन सूट का के लिए फाइल
पार्टीशन सूट गलती से ये फाइल हम अल्टरनेटिव डेयर भी मेरा था सूट मेरा प्लेंट भी अमेंड हुआ था. इसीलिए वो जो लास्ट मोमेंट में बोल रहे थे कि देखी भी थे वो मंगवाया गया था कि अमेंड हुआ है कि नहीं हुआ देखने के
उसको डिलीट कर दिया था. वो प्रेयर को डिलीट कर दिए थे पार्टीशंस को। ये बताइए तो इशू नंबर 5 इज द मेन इशू। इशू नंबर 5 कैसे डिसाइड किया ट्रायल कोर्ट?
हाँ देखा जाए पैरा 32 देखा रनिंग पेज 33
हाँ पढ़िए।
The parties to the suit cannot be paid. They cannot be said to be having any unity of title and possession over the suit property, as both of them were separate purchasers of a specific half portion and remained in possession as per their convenience, without demarcation of their specific half portion. Since a specific half portion was purchased by the plaintiff as such, no any decree for declaration of the share of the plaintiff is required to be passed, nor any demarcation of the share of the party is required to be made. Both the parties have exercised individual and separate acts of possession, and the same was never as joint and co-owners. And the parties in the suit therefore never came into possession of the specific portion purchased by them and continued their possession held by them as tenant of their vendor. The loss of possession by the plaintiff as on 12/3/1995 is disbelieved, and as such the limitation of recovery and possession of the purchased portion, the plaintiff would have started running from the date of purchase of the southern half portion by him on 25/174. The relief of recovery of the position of 70 feet by 14 feet and as described in the Schedule B to the plaintiff is accordingly barred by limitation. The plaintiff as such is not entitled for any relief of possession nor any unity of title and possession in favor of the parties in the suit. Both these issues are accordingly decided against the
ये जो
plaintiff.
लास्ट में है, the loss of possession by the plaintiff as on 12/3/1995, ये डेट कहाँ से आ रहा है?
25/174.
ये पैरा नंबर 32 में लास्ट लाइन, the loss of possession by plaintiff as on 12/3/95 is disbelieved. What is this date?
मेरा बाउंड्री उसमें एग्जिबिट के दोनों के बीच में मेरा जो बाउंड्री था, मेरे बाउंड्री को तोड़ के वो रास्ता में यूज़ करने के लिए किया था, उसी में प्रोसीडिंग चला था। एग्जिबिट के है उसमें हम लोग ने बोला था कि ये मेरा पोजीशन में था, वो बाउंड्री को तोड़ दिया, वहीं से मेरा कॉज ऑफ एक्शन शुरू स्टार्ट हुआ। उसके बाद हम टाइटल सूट फाइल किए 95 में। तो
लिमिटेशन फॉर रिकवरी ऑफ पोजेशन पे डिसाइड कर दिया, उनका एडवर्स पोजेशन पे फाइंडिंग नहीं दिया।
वो हाँ वो क्लेम किया पैरा 23 में, क्या वो जो ग्राउंड में डिक्लेयर है पैरा 23 में, हम एडवर्स पोजीशन के ग्राउंड पे क्लेम किए,
लेकिन उस पर तो मतलब
देखा
एडवर्स
जाए-
पोजीशन का कोई फाइंडिंग दिया है।
अब देखा जाए फाइंडिंग फर्स्ट अपडेट कोर्ट का फाइंडिंग देखा जाए पेज रनिंग पेज नंबर 53।
यस,
Considering the case of first paragraph. Considering the case of both the parties and discussing the evidence adduced on both of the parties, oral and documentary evidence, I find and hold that the plaintiff failed to prove the unity of title over Schedule A property, and the plaintiff has also failed to prove, and the plaintiff is also not entitled for alternative relief for declaration of title, as the plaintiff has not pleaded in his plaint that the defendant is possession their purchased property, and also the suit is not filed under the provision of Jharkhand Building Rent Control Act, as admitted by the plaintiff in para 6 and deposition para 6 and cross-examination in para 29, and the plaintiff independent witness PW 6 para 12 are that the defendant was tenant of original owner. This is the perverse finding, Lordship. Since the relief for
सब्सटेंशियल
recovery.
क्वेश्चन ऑफ लॉ बताइए।
A and B, Lordship. Page number 7 of the substance question. Whether the both could be committed or wrong, it is substantial question of law when the plaintiffs are paid for alternative player for declaration of title in the title of the plaintiff on the basis of transparent.
जो आप लोग इस तरह से सेंटेंस बनाते हैं, आपको समझ में आ रहा है सेंटेंस?
सही हमारे सीनियर
तो ऐसा बन जाएगा आपका क्वेश्चन ऑफ लॉ, तो क्या हम आंसर करेंगे उसको?
मेरे सीनियर का ऑफिस में इसको सही नहीं।
Or the learned counsel appearing on behalf of the applicant. The learned counsel for the applicant has submitted that both the plaintiffs and the defendants were tenants under the original owner of the property, correct?
Yes.
And both of them purchased the property through their legal heirs and successors, although there was no partition amongst the legal heirs of the original owner. He submits that a portion of the property purchased by the plaintiff was under illegal possession of the defendants, and consequently a suit was filed. The learned counsel has submitted that so far as the prayer for partition is concerned, the same was not the appropriate relief, but at the same time the plaintiff had also prayed for declaration of title over half portion of the suit property purchased through registered sale deed dated 25/1/1974. The learned counsel has also submitted that demarcation हुआ था, demarcation नहीं हुआ, आपका म्यूटेशन हुआ था,
म्यूटेशन मेरा होता
म्यूटेशन का कौन सा डॉक्यूमेंट?
इसमें ट्रांसफर जजमेंट में आया
एग्जिबिट नहीं है, म्युनिसिपल रिसीट है, ग्राउंड रेंट रिसीट, ये है क्या ग्राउंड रेंट रिसीट? The learned counsel has submitted that the learned trial court, the learned counsel has submitted that there was no relationship of landlord and tenant between the plaintiffs and the defendants. And one of the issues which was framed by the learned trial court was issue number 5. Is the suit barred by law of limitation and adverse possession and ouster? The learned counsel has submitted that while deciding issue number 5, the learned trial court took up the matter along with issue number 7 and held that there was no unity of title and unity of possession between the plaintiffs and the defendants, as they were never joint and co-owners. And at the same time held that the parties to the suit never came in possession of specific portion purchased by them, and they continued their possession held by them as tenant of their vendors. The learned counsel submits that it has been further held by the trial court that loss of product possession by the plaintiff as on 12/3/1995 was disbelieved, and as such the limitation of recovery of possession of the purchased portion by the plaintiff would have started running from the date of purchase of the southern half portion by him on 25/1/1974. And consequently, the suit was held to be barred by limitation. The learned counsel has submitted that the learned trial court, while deciding the aforesaid issue, which was essentially relating to adverse possession, has not considered as to whether the basic ingredients of adverse possession were satisfied
Yes.
and proved by the defendants. Correct?
Yes.
So far as the appellate court is concerned, the appellate court was of the view that no petition seeking eviction under Jharkhand building rent control was filed. and therefore there was no question of recovery of possession by the plaintiff over Schedule B property, and that the plaintiff was not in possession over it. The learned counsel submits that the findings recorded by both the courts are perverse. And it was never the case of the defendants that they were in possession of the suit property in the capacity of tenant. उनका केस नहीं था ना that they were the tenant over the suit property.
वो भी बोले कि हम को टेनेंट है, डिफेंडेंट भी बोले कि मैं टेनेंट है। पैराग्राफ 13-15 में बोले दासो सुना कि वो भी टेनेंट है।
नहीं, जो आपका जो रिकवरी जिसका करना था उस पोर्शन का तो वो टेनेंट नहीं थे।
नहीं, टेनेंट नहीं थे।
The learned counsel has referred to the considering their court's submissions, this appeal will be heard on the following substantial question. Whether the learned courts have decided the point of adverse possession and ouster in accordance with law, correct?
Yes.
And whether the learned appellate court was justified in observing that dismissing the appeal by observing that the plaintiff never filed any eviction suit under Jharkhand Building Rent Control Act. That these two should be sufficient.
Yes. Limitation भी बोले, the first trial court lords.
हम तो adverse possession तो हो ही गया ना? Adverse possession and limitation दोनों. ठीक है? Let notice be issued to the respondents under ordinary process for which requisites be filed by the applicant within a period of 1 week from today. The records have already been received from the court concerned. Post this case under the heading for final disposal on 16th of April.
बची।
आपका वो फर्स्ट अपील एडमिट करना है?
Yes, sir.
Passport case item 15, first appeal 21 of 2025.
Counsel for the appellant is present. Admit. Issue notice to the respondents for which requisite be filed under ordinary process within a period of 1 week from today. Let the records be received from the concerned court. इसका valuation कितना था सूट का?
40 lakhs notes. पेज 3 में दिया है।
ठीक. Pose this case on 16th April, awaiting service report. Let this order be communicated to facts. Record call for करने का.
Item 18, second appeal 318 of 2019.
Yes, appellant. आप इसका नोट ठीक से बनाएंगे. जो आपका केस एडमिट हुआ ठीक से आप इसका बढ़िया से नोट बनाएंगे, नहीं तो किसी भी कोर्ट को बहुत कंफ्यूजन है. इसका फैक्ट्स बहुत ज़्यादा है. इसमें सबसे इम्पोर्टेंट चीज़ है कि डिपेंडेंट बोला है कि नहीं कि सूट प्रेमिसेस में वो एज ए टेनेंट. अगर वो सूट प्रेमिसेस में एज ए टेनेंट था, देन अंडर सच सर्कमस्टेंसेस हिज टेनेंसी कंटिन्यूज. समझ रहे हैं? इसको थोड़ा देखने का. नहीं, आप तो खाली बता रहे हैं.
मेरे अंदर भी नहीं था, बस 10वीं
आप तो खाली बता रहे हैं. इसका ठीक से नोट बनाइए. ठीक है? टेनेंटेड प्रेमिसेस को खरीदने वाले को रेंट का एंटाइटलमेंट होता है. एज अ मैटर ऑफ राइट इविक्शन नहीं है ना? यस. नॉट टुडे. Eviction suit.
Yes.
Landlord tenant. Yes or no?
Yes.
लिखिए. Essay number 318 of 2019. Learned counsel for the appellant is present. He prays for not today. Post-mortem. Tell me.
Item 19, second appeal 142 of 2020.
I pray this is will taken up to normal also.
नहीं, आप हर केस में ऐसे टाइम मांगते हैं.
नहीं, सीनियर आए हैं.
कोई बात नहीं. 2,000 रुपये फाइन लगा था, आज 20,000 रुपये फाइन.
20,000 तो हम लोग शॉर्ट सी थी नहीं मिलता. 20,000 तो हम लोग शॉर्ट सी थी नहीं मिलता. कल रख दिया जाए मुझे.
नहीं, ऐसे आप जो है ना हर एक केस में खड़ा होकर टाइम मांगते हैं. आपको हम टाइम नहीं देंगे. आप इतना सीनियर हो गए हैं, आपको तो अभी साथ पढ़ेंगे तो आप बता देंगे कुछ.
फाइल भी सीनियर यहाँ से आया नहीं.
फाइल भी नहीं आया है.
फाइल नहीं आया.
तब तो आज एकदम कॉस्ट लगाने ही वाला. नहीं चलेगा. इस तरह से नहीं चलता. ये कब का है? 2020 का. 5 साल में अभी तक एडमिट नहीं कराए. इसका मतलब कोई मेरिट नहीं आपका केस.
नहीं मेरिट क्यों होगा?
5 साल में आप केस एडमिट नहीं करा पाए हैं तो मेरिट नहीं है ना.
कल कर दिया ना. फर्स्ट केस कर दिया.
फर्स्ट केस हम ऑलरेडी एक केस में करते हैं. उनका मैटर.
हाँ, सेकंड केस करते हैं.
नो वन एपीएस भी होता है आपका केस. लास्ट चांस हो चुका है. उसके बाद आपका 1,000 रुपये कॉस्ट हो चुका है. फिर आपका 2,000 रुपये कॉस्ट हो चुका है. आज 20,000 रुपये. कितना टाइम चाहिए बताइए.
निकल रही.
अब 20,000 रुपये एक सुनना पड़ेगा.
20,000 में तुम जिंदगी में नहीं पाए
तो अच्छा है, डीएफडी हो जाएगा. क्या ही दिक्कत है. ऐसे नहीं करिए.
नहीं कल कर देंगे. एकदम कल कर देंगे.
Learned counsel for the appellant seeks adjournment on the ground that he has not brought it back to. He submits that the matter be postponed.
Item 20, second appeal 98 of 2021.
Open the file. Read the trial court judgment. You were the plaintiffs. You have lost in both the courts. Read the plaintiff. Yeah. Trial court judgment. Read. What was the suit for? What was the suit for? Chamber नहीं जाते हैं? Don't go to the chamber. You don't read the files. You don't. Then why have you come? Then why are you here? No. Your chamber only has second appeals and first appeals. Correct? Then you don't read second appeal. You start reading it. Open page number 10. पढ़िए पढ़िए शुरू से पढ़िए. घर में नहीं पढ़ते हैं तो यहाँ बैठ के पढ़िए. Read. देखिए जरा ऐसे नंबर 98 of 2021 Learning Council for the Appeal and Sixth Adjournment. पास होगा?
Yes.
तब तो आप पढ़िए. पास होकर मांग रहे थे एडजर्नमेंट तो नहीं बोलेंगे ना. पढ़िए एकदम तेजी से पढ़िए.
The judgment.
Yes, Judge.
The plaintiff has filed this present suit praying for a decree for declaration of Rayati Kayami subsisting right, title and interest. Right, title, interest and possession of the plaintiff over the suit land for more fully detailed and described in Schedule A of the plaint, and for the order of injunction restraining defendant number 1 to 5, their men, servant, agents from digging any pits for the purpose of plantation of trees over the suit land. The plaintiff's case in brief is that land of Khata number 9, plot number 117 of village Sijua, Thana number 30, measuring an area of 5.10 acres out of 7.70 acres, detailed in Schedule A. The plaint are the settled land of plaintiffs, settled through the grant of two hukumnamas, dated so and so for 5.10 acres and dated so and so for 2.60 acres, respectively, by the then ex-landlord of the village. That late Amru Ko, father of the plaintiffs, with the permission of ex-landlord of village Sijua, reclaimed the land of Khata number 9 appertaining to plot number 117, measuring an area of 7.70 acres by his great labor and efforts, and converted the said land for the purpose of cultivation, and then he approached the ex-landlord Gunjan Mia for settlement, who got the land measured for by Amin and granted Parcha dated so and so, Hukumnama dated so and so, for an area of 5.10 acres after receiving salami of rupees 105 from late Amruko, and rent was also assessed. It has further case of plaintiffs that subsequent upon the said settlement, Amruko again approached ex-landlord for the settlement of another piece of land of Khata number 9 of village Sichua, pertaining to plot number so and so, which was measured by Amin of the ex-landlord, and accordingly Parcha was granted on so and so date. After grant of Parcha, Hukumnama was granted by ex-landlord on so and so for the above noted land, after receiving salami of rupees 35 from said Amrugo, and the possession of settled Amrugo was accepted and confirmed. It has been pleaded that after such settlement, Amrugo remained in peaceful possession of the settled land, and after his death in the month of Sawan of the year 1998, his three sons plaintiffs inherited the said land and exercised all acts in possession over it. The plaintiffs grew crops such as dhan, wheat, maize, etc., and utilized the same in the manner best suited to them. The plaintiffs have averred that when Bihar Land Reforms Act 1950 came into force on 25th September 1950, by notification number 5067 dated 24th September 1950, and the village Sijua, Thana number so and so, district Hazaribagh, vested to the state of Bihar, the ex-landlord's interest was also vested, bearing the land of Schedule A, which has changed its character as Rayati on the basis of village settlement paper, and Amruko was also recognized as Rayats of the state by the issuance of government rent receipts. in
Case
his
number
favor.
98 of 2021 for the learned counsel appearing on behalf of the appellant as the court time is over, this case for further hearing.